It was brutal. It was a brutal murder of my mom.
Hunsaker's body was later found in the picnic area.
Nobody wants to grow up dealing with the loss of a parent from a young age in such a horrific way. You don't. This is all I know of a life.
She had been strangled, her throat had been cut.
We have to deal with the way that our lives are every day without having her as a grandma, great-grandma, mom, all those things she lost out on. And a small little justice for us will be amazing.
So, Mr. Menzies, the court is going to set an execution date in this matter.
We're not cold-hearted on this. This is not going in with anger and vengeance, and it's going in for closure.
Maurine Hunsaker was in her 20s when she was robbed, kidnapped, and murdered nearly 40 years ago. Fast forward to July of 2025, and the man who did it, Ralph Menzies, was given an execution date for the 4th time. For decades, he has fought the death penalty through appeals. And now in 2025, he suffers from dementia and has opened up a whole new line of appeals centered around not understanding why he would be executed. Here is the full story of Maurine Hunsaker and Ralph Menzies. It begins back on February 25th, 1986, right here when 2 hikers who were hiking in the Storm Mountain picnic area of the Wasatch National Forest here in Big Cottonwood Canyon, which is just to the east of Salt Lake City, Utah, found Maurine's body. She was bound, her throat was slashed, left in the cold to die. On February 23, 1986, Salt Lake County deputies found this gasomat station empty, the cashier gone, coat left behind, and $70 missing. 26-year-old Maurine Hunsaker was working that day when Ralph Menzies showed up. Later that night, Maurine called her husband saying that she'd been robbed and kidnapped. During their call, the line went dead. Maurine never made it home, and 2 days later, her body was found. Here is a news report from the 1980s detailing Menzies' arrest.
The man suspected of abducting Maurine Hunsaker was already in jail when he became a prime murder suspect. West Valley Police had jailed Menzies on a warrant for theft. His actions at the booking desk would eventually expose him as an accused killer.
The officers that arrested him asked him if he had anything in his pockets that he wanted to divulge, at which time the individual became extremely agitated and nervous, and he jumped and ran into the back room area.
Hunsaker's driver's license and other identification were pulled from a clothes bin in the booking area. Investigators say the ID was dropped there the same day 2 witnesses saw Hunsaker and a man at the Storm Mountain picnic area. Hunsaker's body was later found in the picnic area. She had been strangled, her throat had been cut. Detectives say they used jail booking records to narrow down the list of suspects and a description of Menzies and the car he was allegedly driving to pinpoint him as a suspect. A later search of Menzies' home turned up additional evidence, including the victim's purse, according to the probable cause statement attached to the charges. His home was only a few blocks away from the gasomat station where Hunsaker was robbed and abducted. Brian Schiffer, KUTV News.
The case quickly made headlines as Menzies was charged with murder. His cellmate later told detectives that Menzies confessed to killing Maurine to keep her from testifying. This is Ralph Menzies being escorted into Judge Raymond Ono's 3rd District Courtroom on June 27, 1986, where he pled not guilty to robbing, kidnapping, and murdering Maurine. The prosecution built the case on witness statements, timeline analysis, evidence found on Menzies at the time of his arrest and at his apartment, and statements Menzies made to others after the crime. After a month-long trial, a jury convicted Menzies of murder and kidnapping. The trial judge sentenced him to death. That was in 1988. And what followed was a judicial maze of post-conviction appeals, motions, hearings, and competency questions that would drag on for nearly 4 decades. But the case took a new turn in the early 2000s. Mark Shurtleff was the Utah Attorney General for 12 years and is intimately familiar with this case. He pushed for Menzies' execution in 2003 when a death date and execution by firing squad was set. Then Menzies' legal team changed.
So a whole new attorney has to get involved, learn the case, start the process again.
Menzies' legal team began filing motions for DNA testing on evidence, claiming that it could prove his innocence or undermine the state's case. In 2004, the court denied the motion, stating the DNA evidence was not likely to produce exonerating results. 2 years later, in 2006, a second DNA motion was filed. This time, the court agreed to limited testing, but the results were never strong enough to warrant a new trial.
I believe that there should be a death penalty in limited cases, and if a jury listens to the circumstances and the reasons for a death penalty and they order it, then it should be done, and it shouldn't take 20, 30, 40 years.
Between 2007 and 2015, dozens of filings hit the docket. Motions to reopen discovery, requests for independent experts, motions for new attorneys to be appointed, and challenges to the constitutionality of Utah's execution procedures. Here are both Ralph Menzies and Maurine's son, Matt Hunsaker, during that stretch of appeals.
You're not really living here, you're just existing?
My mom did not deserve to be tied to a tree and her throat slashed at all. And for this guy to come in here and say his attorneys didn't do the right paperwork in time just anger the family.
Multiple search warrants were signed to access evidence and property, but the state maintained nothing had changed. The conviction stood, and as years turned into decades, each time an execution warrant seemed close, a new motion emerged and the clock was reset. As of July 2025, Menzies had an execution warrant signed 4 times.
We are watching somebody's life being taken from them, and with respect to that, it's, we do have emotions, we do have feelings. We're not cold-hearted on this. This is not going in with anger and vengeance, and it's going in for closure.
Matt was just 10 years old when Menzies killed his mother, and he's been waiting nearly 40 years to see him be executed.
It takes a lot to have that. It takes a lot of your energy. It takes a lot of your focus to have that much anger and hatred towards anybody. And I've chosen years ago not to travel that road, not to let that affect my life, let that affect my kids' lives.
Maurine's mother passed away before seeing Menzies executed.
She was a firm believer that she wanted him executed for what he did. And in her mind and in her soul, that was what needed to be done. That was what was right for her and our family.
Matt goes to the hearings waiting for the appeals to stop so he can honor the memory of his mother.
It's kind of a void in the whole family, and it's hard to see that it's the short 10 years that I had with her and how amazing and how much she made me the person that I am. All I can do is preserve her legacy and shine the light on what needs to be done.
January of 2024, the Utah Attorney General's office files a motion to set an execution date, which was not the first time this had happened in this case. And it was at that moment that Menzies' defense team appealed and argued that he was suffering from dementia and mental decline and wouldn't fully understand why he was being executed. Because under the law, even a convicted murderer can't be executed if they don't fully understand the reason behind their punishment. So that set off an entirely new and different legal fight here in the courts, centered around this one question: is Ralph Menzies well enough to be executed? In March of 2024, the court approved expert examinations from both sides. Over the next several months, the case delved deeper into mental health evaluations, expert witnesses were assigned, and contact visits were ordered.
It is true that we're here discussing Menzies' capacity of his competency, but we also are forgetting why are we here? It's for what he did in 1986 and what he did and how he did it and what the heinous crime that he committed.
Video recordings were initially mandated, then struck down by court order. The hearings argued over the results of the evaluations played out late into 2024. Dr. Thomas Hyde evaluated Menzies twice during the competency hearing period. He testified in November of 2024.
In this case, it's getting more disorganized, and that's what you would expect to see as a dementia progresses.
Dr. Hyde testified that people with vascular dementia sometimes appear to understand what's happening around them, but it doesn't always mean that they do.
In his case, for a variety of factors, he is at high risk, and it has unfortunately come to fruition that he has cerebrovascular disease of a significant proportion.
Menzies has vascular dementia, which falls under a larger umbrella of the disease caused by a repeat of small strokes in the brain. The state provided evidence and argued that Menzies understands his current legal proceedings. The state says Menzies told his sister that he had an MRI as part of the evaluation and explained that, quote, technically, if I do have dementia, they can't kill me legally. In June of 2025, Judge Matthew Bates found Menzies competent to be executed. In his ruling, Judge Bates wrote, although Menzies has shown that he has vascular dementia, he has not shown by a preponderance of the evidence that his mental condition prevents him from reaching a rational understanding of his punishment or the state's reasons for it. Therefore, he has not met the burden to show he is incompetent to be executed.
We as a society have a much better understanding of mental illness than we had 10 or 20 years ago.
Robin Mayer is the executive director of the Death Penalty Information Center. They are not an advocacy group. They track the use of the death penalty and provide data and analysis on its use. Mayer says the data shows the longer someone is in death row conditions increases and accelerates the aging process.
We also see that a number of these people who have been on death row for many years are suffering the effects of that long-term isolation.
The U.S. Supreme Court has looked at the issue of mental competency 3 times. The facts in Menzies' case are not that much different than those cases.
This is a claim that can be made only at the time when someone's execution is imminent. What we are seeing around the country in many places now is increasing claims of mental incompetency at the time they are scheduled to be executed.
For decades, the courts, backed by hundreds of years of common law, have said executing people who are insane is not constitutional. Later, cases refine that even further to show the condemned must not only be aware of the execution, but be aware of the meaning and purpose for it.
That's what's required for that execution to be a constitutional one. And that's what's at issue here in Mr. Menzies' case.
The court at this point finds no legal reason not to issue a warrant of execution and to begin the process of moving towards that execution date.
On July 9th, 2025, nearly 40 years after Maurine Hunsaker's murder, Judge Bates signed a death warrant the 4th time Ralph Menzies has watched a judge set a date for him to die.
So, Mr. Menzies, the court is going to set an execution date in this matter of September 5th of 2025, which is more than 30 days, but not more than 60 days from the date that I am issuing this order. I'm going to sign this order now.
But the legal fight is still not over. There's uncertainty over if he will be executed. Menzies has petitioned the court for another mental competency evaluation, arguing that his mental capacity has declined since his last evaluation in 2024.
We remain hopeful that, the courts or the clemency board will recognize the inhumanity of taking a man like him into the death chamber, taking him out of his wheelchair, and executing him. It's wrong, and Utah can do better.
Eric Zuckerman is one of Menzies' attorneys.
Increased confusion, difficulty understanding his surroundings. He has difficulty feeding himself. He has difficulty, getting out of bed in the morning. He has difficulty putting his own shirt on. These are all things that, they're emblematic of someone who has dementia. It's becoming more and more childlike and has more and more difficulty grasping what is happening around him on a daily basis.
For Maurine's family, this may finally close a chapter they say has been open for far too long.
I just turned 50 this year. It's been a long time. The process has taken a long time. It's hard to swallow that it's taken this long. It does hurt.
Matt has watched judges set a date for Menzies to take his last breath. He thinks this time will be different.
Any able-bodied person, if I woke up this morning and I was in a jail cell and not knowing anything about my life, I would be asking people, and they have not produced any evidence whatsoever that he's waking up confused in the morning, that he doesn't know why he's there. They're just saying that he doesn't understand things, which I believe it's stretching the words of how the competency thing goes. And I also will say that I believe he's now well educated on what he needs to do. Unfortunately, this is setting a precedence for future victims that are going to have to go through with their cases, that anybody's going to claim that they're incompetent.
He's preparing to see someone lose his life.
This is going to be a humane sort of a way. his life will be over in mere seconds. My mom, we don't know how long she stood there and suffered in that grove, how long she was, bled to death, and how much she felt and knew.
Menzies, once a violent killer who sparked fear and anguish, is now an aging inmate on death row with a diminished mind. That question remains: will the sentence be carried out as ordered, or will one last legal move delay his execution once again? I'm Jim Spiewak. Thanks for watching this YouTube original.